But the frame message for boy.
Oh, frame that the headroom was too much.
The guy has gone. The frame message like who am married.
Okay, as in the speaker.
When he was there, yes. As in we go to place you are 12. Go to upload only large size.
But we are Zoom. Go back call it eject go and then you say don't distract yourself.
So the voice will go into the stream.
The chief registrar.
So, sir, it's important you tell everyone not to be alarmed when they see this.
It's not a bomb. They said this is a microphone.
It's a microphone for the online stream. So the voice will go into the online stream.
No, the speaker is just waiting for everyone to see. Yeah, she's going. Start the National Anthem before him.
His idea, she said when she comes then the National Anthem. You understand? Let Christy go and call her.
Okay, let me, okay. My Lord, the Honorable President of the Court of Appeal, my Lords, the Honorable Presiding Justices of the various divisions of the Court of Appeal, my Lords, the Honorable Justices, we are about to start, but beforehand, we would like to have a member of the hotel staff come in to give us a safety talk. As we all know, we are in unusual times, and they are mandated by law and by the policy of the hotel to give us a brief safety talk on COVID-19 for the next 5 or so minutes. So we will invite you to come forward and as an emergency. Okay, thank you. Emergency safety talk. Please can you come?
Good evening, distinguished guests. My name is Steve. I'm the safety officer of Lagos Continental Hotel, and safety is priority. So it is our principle that whenever we have an event in our hotel, we have to give safety briefing just in case there's an emergency. Let us know what to do and what not to do for our safety purpose. All right, sir. You are presently in our Grand African Ballroom, located on the 3rd floor of the hotel. In the unlikely event of fire or any other emergency that may set the evacuation alarm on, please do not run, don't panic, but walk briskly through any of the 6 exits. We have 1, 2 by the left side. These 2 will take you to staircase B and staircase C, which will eventually take you to the ground. The other 4 emergency exits are behind us. These 4 emergency exits will take us to the foyer. The foyer is a large open space outside. Please, while at the foyer, do not use the elevators, as all the elevators will be grounded. However, we have exits to the lobby and also to the ground floor. The spiral staircase here will take us down to the lobby, while the staircase at the back will take us to the ground floor. So we have various service firefighting equipment located at strategic areas in the hotel. At the foyer, we have 5 there. Then we have alarm systems within this hall. 2 are at the back, while we have 1 in this hall here. So please, our restrooms are located beside the elevators, by the right side of the elevators. For the privacy, to protect the privacy of our guests, the ballroom, the restrooms do not have CCTV coverage. Please ensure you don't leave your personal belongings unattended. But I'm sure we don't have any thieves here. Thank you for choosing Lagos Continental. Enjoy your stay.
He appears to be very nervous because he has left the building. I would have loved for him to tell us more about the COVID-19 regulations in hotels. That is neither here nor there. My Lords, at this juncture, we ought to be starting, but we are awaiting the arrival of the paper presenter who is in the building. So in the next 5 minutes, hopefully we shall stand up and recite the national anthem and the pledge. We can start with the national anthem. Absolutely. May we all please stand and sing the national anthem together. Thank you. Arise, O Nigeria's call to serve the fatherland with love and strength and faith. The labor of our heroes past shall never be in vain. To serve with heart and mind, First stanza, please. I pledge to Nigeria, my country, to be faithful, loyal, and honest, to serve Nigeria with all my strength, to defend her unity, and uphold her honor and glory. So help me God. At this juncture, we would like to invite to the podium the Lord, the Honorable Justice J.H. Sankey, the presiding justice of Gombe Division, to please give us the opening prayer.
You have to bring down the microphone a bit.
It's okay. It's okay.
Yes, fine. Let us pray. Almighty God, your instruments of justice, peace, and progress. We come to you at this hour seeking your blessing. We also ask for your help as we are gathered together at this first session of the first working retreat and conference of the justices of the Court of Appeal. Father, we pray that you imbue our president with wisdom as she leads this court at this auspicious time in the life of our country, Nigeria. We also pray for the presenters who have been specially and thoughtfully chosen to speak to us throughout the week. We especially pray for our eminent, illustrious, esteemed, and distinguished presenter, the First Lady Silk in Nigeria, a lady in every sense of the word, even though she stands shoulder high above even the men in the legal profession. Chief Folake Sholanke, Senior Advocate of Nigeria, Officer of the Order of the Niger. Father, we come with expectation to receive from the wisdom and experience dripping from her lips and out of the abundance that you have inculcated into her. We also pray for the honorable justices of this court, that you will continue to guide us in the conduct of our work with a sense of justice and impartiality, as well as a spirit of joy and enthusiasm. Give us the desire to find ways to excel in our work and to do so without complaining. Our Lord and our God, may the matters we discuss here and throughout the week serve as a catalyst to move us forward as a court and cause us to advance and see growth in all areas of our lives. Finally, Father, we pray for strength in our commitment and courage in our service. I close this prayer with the word of God in the book of Micah, chapter 6, verse 8. I quote, "And what does the Lord require of
May we please give the Lord a round of applause. Thank you very much, my Lord, for the heartfelt, for the sincere, presenter will be coming in any time from now, so in the meantime, please let us tarry a little while. She's a mother, a grandmother. She is a woman of many firsts, and we are really privileged to have her among us to be able to impart some of the knowledge which she has garnered over close to 6 decades of legal experience. So we present Chief Mrs. Folake Solanke, Senior Advocate of Nigeria, recipient of the Order of the Niger. But before she comes to the podium, I beg your pardon. But before she comes to the podium, we shall, with the kind permission of the Honorable PCA, say a few words, a brief citation on the paper presenter. And that citation will be read by our own Honorable Acting Chief Registrar. Please come to the podium, sir. Thank you.
My Lord, the Honorable President of the Court of Appeal,
Justices of the Court of Appeal present, the paper presenter, Chief Qualification, SA and COA. You are welcome. I have the instruction and the director of the Honorable PCN to give a brief profile of yourself. Honorable Chief Folake Solanke SA and COA was born in Abeokuta on Tuesday, the 29th day of March, 1932, to the illustrious family of Chief Jacob Shobega Odolati, alias Zabilev Jacob, otherwise known as Alabukun of Ikorodu, who made his name and fame in Abeokuta. He was a pharmacist and proprietor and founder of Alabukun Fatin Medicine Stores, Safon, Abeokuta. Her father was the inventor and manufacturer of Alabukun powder and many other medical products. His photograph is depicted on the popular Alabukun powder sachet, which consumers of beer and others take for instant relief for all ailments. As children, they work in their home factory during school days, followed by substituous feast after factory activities. Her mother, Shekumade Oludate, died young when she was 2 years old. She attended kindergarten and primary schools in Abeokuta, namely Agboaka School and Imo Girls School, respectively. In 1944, she sat for the entrance examination into Methodist High School, Lagos. She was told by the headmaster at Imo Girls Schools, Abeokuta, that her result was spectacular and she was placed in Form 2 instead of Form 1. And she attended Methodist Girls High School, Lagos from 1945 to 1949, where she obtained her first grade in the senior Cambridge School certificate examination and was a school prefect and games captain. She was a runner and loved netball game. She worked for a few months at a ministry in Lagos and found her clerical work there unbearing and boring. She was relieved to leave the ministry. She left in January 1951 and was at King's Castle, Oftentine, then in the University of Durham, and now University of Newcastle, Oftentine, from 1951 to 1955, where she obtained BA degree and diploma in education. She taught Latin and mathematics as a teacher in two public schools, to wit, Firefest Corner School, Great Kings Hill, High Wycombe, Box, and St. Monica School, Clanton-on-Sea, Essex. She got married to Dr. Toriola Feshantan Sholake in London in 1956. He later became a professor emeritus of surgery before he passed away in 2001. In 1960, she returned to England and worked as student officer number 7 at Nigerian High Commission, London. From 1960 to 1962, she read law at Garris Inn, where she passed all her bar examinations in 22 months and was called to the English bar in Assacia in May 1963 in London. She also enrolled as a lawyer in the Supreme Court of Lagos in Nigeria in the same month and year. She was a full-fledged in her brother-in-law, Mr. M.A. Adeshanya, who later became a Lagos State High Court judge. She was also a learned junior in the law chambers of Chief Ephraim Williams from 1963 to 1966 in Ibadan. In 1966, she established her own independent legal practice with overt assistance and encouragement of her husband and under God's direction with boundless grace and power. Her law chamber was the first female law office in Ibadan. It is named Alabuku Law Chambers in honor of her father. She's delighted that some female lawyers have followed her professional example. In 1981, she was elevated by the Supreme Court of Nigeria to the prestigious rank of Senior Advocate of Nigeria, SAN, the equivalent of Queen's Counsel in England, the first female lawyer to be so elevated. She has now practiced serious advocacy for over 54 years. 54 years, 36 of them as the first female senior advocate in Nigeria, and now tired. In 1970, she joined the Prejudicial Junta International, a global organization of executive in business and in profession, working for the advancement of women. She has received a number of university doctorate degrees to wit: 2007, Olabisi Onabonje University, Ago A doctorate degree of Doctor of Letters, Doctors of Law LLD, honoris causa. 2011, Obafemi Awolowo University degree of Doctors of Letters, DLTT, honoris causa, the highest a university can bestow on any recipient. The International Bar Association is Distinguished International Women Lawyer Award in London. 2013, University of Ibadan, Doctor of Letters, honoris causa. 2013, Nigeria Defense Academy Kaduna University, Doctor of Letters, honoris causa. She was made a fellow of Nigeria Institute of Advanced Legal Studies in 2011. She has also been honored by numerous institutions for which she is profoundly grateful. She has over 100 papers and publications. In 1998, she published a book titled The Trial of Our Lord Jesus Christ and the Trials of St. Paul the Apostle. The two books received commendation from the Pope in the Holy City and the Archbishop of Canterbury in London. She also published her autobiography in 2007 titled Reaching the Stars, the biography of Olanke Sholanke, a compendium of lectures and other papers in 2012. From 2016 to 2019, more lectures, more speeches, more papers, more books, more honors, more awards, etc., and more recognitions. She is blessed with 3 children, medical doctor, stroke lawyer, Sheyemi Sholanke Koya, qualified in both disciplines, medicine and law in Nigeria and the US. Babatunde Sholanke, civil engineer, Busola Sholanke, mathematician. She is a devout Christian and belongs to the All Saints Church Ibadan, one of the Bible Church and prayer group, and the Chapel of Resurrection. She's a widow. It's a great honor to have you here. It's a great honor and privilege to have you here. Welcome. Guys for her? Thank you, ma'am.
Well done, well done.
It's okay?
Yes, I want my water to be near me.
Okay.
Let me put it. Water. Yes, thank you. Welcome. Thank you. Bless you. I salute
the Honorable Justice Monica Dongan Mensem, the President of the Court of Appeal, other justices here present, and respected guests. I'm most gratified by the very eloquent introduction of me by the gentleman. I'm very, very grateful to you. May God continue to honor all of us. My presentation is in two parts. Part one, the challenges, and part two, the way forward. I want to start with a plea. The President of the Court of Appeal gave me the title of my address, namely, Court of Appeal, Challenges, and the Way Forward. Challenges are problems requiring solutions. I am not here to abuse or embarrass or condemn any member of the judiciary. However, it is not possible for me to articulate the topic without dealing with some sensitive issues. I cannot play the ostrich, but must deal with our present reality and speak truth to judicial power. I ask you humbly to accept my statements in good faith. I offer my recommendations bona fide because I share your concerns for the profession. Those who know me can testify, even on oath, that I have the greatest respect for the judiciary. We are all here to deliberate on how to restore the golden age of our judicial system and the administration of justice in our beloved country. Inadequate funding of the Court of Appeal. Section 81(3) of the Constitution of Nigeria, as amended, provides any amount standing to the credit of the judiciary in the Consolidated Revenue Fund of the Federation shall, I emphasize the word shall, be paid directly to the National Judicial Council for disbursement to the heads of the courts established for the Federation and the states under Section 6 of the Constitution. The words of the Constitution are so plain that no ambiguity can be attached to them. Thus, it is incomprehensible to know why what is happening is happening. And the word shall implies is mandatory, that it should be paid directly. Recently, President Buhari signed an executive order number 10 in an attempt, an effort to ensure that the provision for direct payment to the NJC is obeyed. But regrettably, to date, politics and politicians have rendered Executive Order number 10 impotent. As we know, there is perpetual public lamentation about the insufficiency of budgetary appropriation for the judiciary. I'm so sorry, I really I do not know what happened. I fail to understand why the appropriation for the judiciary has remained 110 billion for 2 years in succession, and also for the forthcoming 2021. And we know that last year, many appointments were made to the Court of Appeal. And even this year, 8 new justices of the Supreme Court have been appointed. So one doesn't know why the judiciary is being held to 110 billion. Without adequate funding, the judiciary, the independence of the judiciary is a myth. It is compromised. A government which starves the judiciary of funds is not promoting the rule of law. Consequently, in the context of insufficient funding, I extend high commendation to the President of the Court of Appeal for choosing a local venue for the retreat and conference, thereby saving millions of naira, which can then be applied to other urgent needs. Well done, President. I am not aware that a foreign country has ever come to Nigeria to hold her retreat or conference, judicial or otherwise. Appointment of a justice of the Court of Appeal. Once more, I extend copious congratulations and felicitations to the President for the elevation to the lofty position of President of the Court of Appeal. Offer prayers for an outstanding tenure. I wish the President divine empowerment, excellent health, and stamina. I also appreciate the invitation extended to me by the President to present a paper at this important and strategic retreat conference. I recall with a measure of nostalgia the President's tenure as the presiding justice of the Ibadan Division of the Court of Appeal some years ago. The President's performance was memorable and impressive. As we all know, the Court of Appeal is a creature of the 1999 Constitution in Section 2371. And Section 2373 states, a person shall not be qualified to hold the office of a justice of the Court of Appeal unless he is qualified to practice as a legal practitioner in Nigeria and has been qualified for a period of not less than 12 years. There's also the Court of Appeal Act 1976, number 43. It is noted that the general provisions in the Act do not contain any reference to the expected quality of the performance of a justice in relation to ethics, integrity, legal scholarship, and erudition. There's nothing in the Act with which to assess a candidate's computer literacy and proficiency. Although the Constitution is not expected to contain such details, sadly, the Court of Appeal Act is also silent on those crucial prerequisites for the appointment of an honest and competent Justice of Appeal. Now, Rule 10 of the Code of Conduct for Judicial Officers states prohibition of acceptance of gifts, bequests, loan, favor, benefit, advantage, bribe, etc. Tragically, the recent corruption index in the world lists the Nigerian judiciary as number 1, followed by banks. Corruption index in the world, Nigerian judiciary as number 1. Federal character. The provision of Section 14(3) of the Constitution on federal character continues to inflict a lot of damage on the polity because merit and excellence have been sacrificed on the altar of mediocrity. The damaging section provides, quote, the composition of the government of the Federation or any of its agencies and the conduct of its affairs shall be carried out in such a manner to reflect the federal character of Nigeria and to promote national unity. Most regrettably, the undesirable effect of federal character is threefold. 1, it has sacrificed merit and excellence on the altar of mediocrity and incompetence. 2, has exacerbated ethnic, tribal, and religious contentions and rivalries. And 3, has failed to promote national unity. It is deplorable that people now focus on how many appointments are due to their own area or zone. They do not consider who is the best to be appointed on merit to a particular position, including a judicial position. The distressing consequence is, with all due respect, that some judicial officers perform below expectation. As long as appointments are based on federal character, quarter, zone, and not on merit, the quality of judgments will continue to plummet to the impairment of the judiciary. Courtroom hearing. We must realize that even litigants can form an opinion whether or not the judicial officers are demonstrating legal knowledge in the handling of an appeal. If they do not, in such a situation, the judgment of that particular court will not inspire confidence in anyone. Hearing of an appeal in the courtroom is a serious business for the justices, the counsel, the litigants, and members of the public. There are instances when it is plain to any keen observer in the courtroom whether or not a justice had read the files and was prepared for the hearing of the appeal. Being unprepared is as bad as being unlearned. A lot of discontent and disenchantment of the populace is caused when the justices appear unprepared for the hearing of appeals. Indeed, there was a time when it was exciting for the bench and the bar to engage in legal banter over the law during the hearing of a matter when both the judges, the justices, and the counsel were ready to prosecute the case to the enjoyment of the audience. Such banter can only happen when both the justices and the counsel are ready and on top of their expertise. Personnel. There are now 20 divisions of the Court of Appeal. I do hope I'm correct. 20 divisions? No? Thank you. I'm told that there are 20 divisions of the Court of Appeal. With the recent creation of new four in Gombe, Kano, Asaba, and Oka, consequently, some staff have been deployed from some old divisions to man the new registries of the new divisions. This situation must have created some insufficiency in staff requirements which the justices need to facilitate their burdensome work. Research assistants. Generally, there are no research assistants provided for the justices. I know some judicial officers who engage and pay research officers out of their own salaries. The provision for salaries and allowances in the Court of Appeal does not include salaries for research assistants. Inconsistencies in opinions of panels and divisions of the Court of Appeal. Another serious challenge is the inconsistencies in the opinions of different panels and different divisions of the Court of Appeal on similar facts and applicable laws. This is an extremely serious problem because inconsistencies pose a huge dilemma. Poses a huge dilemma for the High Court and the State High Court as to which of the different opinions to follow on the principle of stare decidendi. Now, corruption. Now, it boggles the mind and tortures the soul. The corruption in our justice delivery system is now the talk of town, anywhere and anytime. Thus, there's a massive erosion of the trust and confidence which the people should have in the administration of justice. Indeed, when I jubilantly entered the profession in 1963, there was neither a whisper, nor a rumor, nor an allegation of corruption, even in the magistracy. However, and tragically, in the last few decades, the Hydra-headed monster has gradually crept into the legal system to the point that the entire judiciary is now erroneously being tainted and painted and polluted with the dirt of corruption. In my 57 years at the bar, with 39 years of them as the first female senior advocate of Nigeria, I have never been so distraught about the corruption label which has been wrongly plastered on some of us innocent members of the profession. This is the calamity which the corrupt ones among us have inflicted on our one and only legal profession. This is a disaster for the legal profession and the country. Now, I enter a caveat, as I always do in my public speeches, namely, that there are judges who abide by their oath of office and labor day and night to render judgments based only on the facts presented and the applicable laws without any extraneous consideration whatsoever. I applaud them. Most unfortunately, however, the members of the public think otherwise. They think we are all corrupt. Judges, SANs, lawyers, all of us. The contempt which the people now have for our judicial system has been publicly manifested when a fellow wearing a judge's robe and wig, a pair of slippers with a machete in his right hand and a file under his left armpit, was walking on the street in the broad light of day in Lagos, and no one could challenge him. Not even a citizen's arrest was attempted. Infandum, I say, unspeakable. I've never witnessed. Let me stop. In addition to the wanton debasement and desecration of our judicial system, the courtrooms, including the Lagos Igbo Shere High Court, the magnificent edifice where the English legal system first took root, was burnt down with the furniture, documents, books, files, historical records, archives, etc. So were the Court of Appeal buildings in Lagos and elsewhere. That was the day of infamy for the legal system. It est, the 21st day of October 2020. In my anguish, I sent a text of commiseration to the President of the Court of Appeal. I also sent a message to the Chief Judge of Lagos State and the Lagos Judiciary. I did not have the telephone number of Justice Ike, the presiding justice of the Court of Appeal in Lagos. I hope I'm right. But I had the telephone number of Justice Kolawole, Gabriel Kolawole, JCA, and I spoke to him on the telephone as a point of contact for all the justices of the Court of Appeal. Words fail me to describe my intense sorrow for the bedlam that was inflicted on the law on that day of infamy. These egregious acts of mayhem perpetrated on the courtrooms are heartbreaking and soul-destroying. However, let us remember that people do not destroy what they respect and value. This is currently the lamentable state of our judicial hierarchy, of which the Court of Appeal is a prominent part. Section 3987 of the Administration of Justice Act 2015. This section provides that a judge in the High Court who is elevated to the Court of Appeal could come back and conclude a part-heard case. In the Uzo Kalu case, the Supreme Court knocked down the provisions on the ground that the fiat permission of the Court of Appeal, granted by the immediate past President of the Court of Appeal, the Honorable Justice Zainab Adamu Bolkachuma, before being sworn in. Appeals from the decisions of the elections tribunals. It is most dangerous for some judicial officers. The Court of Appeal hears appeals against decisions of electoral tribunals, apart from the exposure of the justice to the pollution of politics. The appellate justices are also removed from their division to go and preside over electoral appeals. The absence caused by these appeals and other assignments exacerbate the congestion in the Court of Appeal and prolong the inordinate delay The level of security for the appellate justice appear to be minimal. The court buildings and courtrooms do not have sufficient cover, which situation is dangerous because the justices perform a sensitive job. Every judgment has a winner and a loser. So there are potential enemies galore for justices. May God protect all of us from our enemies as we discharge our professional duties. Deo volente. The gatemen are often left to protect the court premises. I go to part 2, the way forward. Qualification for appointment as a justice of the Court of Appeal. The most critical stage for the good performance of the Court of Appeal relates to the process of appointing appellate justices. The 12-year qualification for eligibility for appointment is merely to serve to satisfy the constitutional provision as a basic qualification for the elevated position. It is postulated that this requirement is insufficient to ensure that the person is fit for the lofty appointment of the justice of the Court of Appeal. There must be other ways for the National Judicial Council to assess the character, legal knowledge, experience, integrity, and ethical disposition of every candidate being considered for judicial office. Such an investigation is crucial, particularly now that the legal profession is in a dire state of disenchantment with the populace. Appointments must be on merit. A candidate for judicial office without a computer competence, computer knowledge, is disqualified for appointment. It is recommended that serving justices who are not computer literate should be given a period of time, perhaps 3 months, to undertake a computer literacy course. If a justice, after the course of study, is still unable to grasp the rudimentary concepts of computer knowledge, which is now a sine qua non for the effective judicial performance, the judex should retire with full benefits. In this context, there's no gainsaying it that information technology, IT, has overtaken all human endeavors. Thus, it is recommended that the Court of Appeal must tackle this challenge with vigor and determination. Experts in the field of information technology should be engaged to equip the courtroom with IT devices and conduct training sessions for judicial officers. Knowledge is cumulative. We all learn every day. Otherwise, the brain will vegetate. It is canvassed that members of the judiciary should at least be conversant with the rudiments of information technology to enable them access information easily. IT has come to stay. It is the new reality of our times. I hope for better and not for worse. The legal profession has gone global. Now, at 88 years of age, you will excuse me, I have to have some water. The legal profession has gone global. The law school should prepare students for global practice to become lawyers without borders, like doctors without borders. However, it is important to note that we should not only seek information on Google. We should apply our own minds and brains to resolve legal problems. As an aside, in my lectures, I always warn law students not to rely on the cut and paste methodology, but also to use their own brains. I have to come back because of recommendation to corruption. It is imperative that the candidate for judicial office must be honest and, like Caesar's wife, be totally without blemish, because corruption destroys the very fabric of the legal system of any country. Corruption and the legal system are mortal enemies. The law cannot survive to perform its regulatory role in the society if it's being administered by a corrupt judiciary. Anyone, including a justice, must be punished for his or her crime. No one should commit a crime and get away with impunity, and the public should know that an erring justice has been punished. Rule 10 of the Code of Conduct of Judicial Officers must be strictly obeyed. Recording devices. The long handwriting of physical court recording by the justices is archaic and should be abandoned and replaced with recording devices to facilitate all court proceedings and enable the justices to concentrate on the proceedings without the distraction of handwriting everything. Government must upgrade budgetary appropriation for the judiciary. A static 110 billion every year is incomprehensible and deficient. Competent research assistance. Further, justices should be assisted by competent research assistants in the preparation of judgments. Justices need the assistance of competent research assistants. The justices should not have to employ and pay their research assistants. There should be provision in the Court of Appeal Act for them. Courtroom environment and facilities. Courtrooms should reflect the aura, dignity, and majesty of the law. The justices should be comfortable in a courtroom to adjudicate on cases before them. The court must always inspire the bench, the bar, and the litigants to believe in the efficacy of the judicial system. The courtroom must reflect the nobility of the judicial system. Security. The issue of security is a matter which was now engaged the urgent and serious attention of the authorities. Having regard to the day of infamy when court buildings came under deadly assault. Security of court premises must be adequate. It is not enough to expect gatemen to be responsible for the security of the court premises. On the day of infamy, when disaster struck, the gatemen ran away for dear life. No one can blame them for disappearing. I would disappear. Inconsistencies of judgments. The Court of Appeal has to tackle the disturbing question of inconsistencies in judgments of panels and divisions. I congratulate the court on the Court of Appeal reports, which are available in electronic and hard copy, I understand. I recommend that consideration be given to using the report to help in reducing the extent of inconsistencies. When justices read the reports, that exercise ought to bring to their attention and knowledge the previous opinions of their brother justices. Seminars and workshops should be designed to deal with the problem of judicial inconsistencies in judicial opinions of the same court. Now that we have 20 divisions, the serious problem may increase. The Court of Appeal owes it to the High Court to deal with this judicial problem. Case management. It is important, having regard to the volume of work in the court docket, to embark on case management training. Case management will involve both the justices and the registries for better performance of the court. I recommend that management training programs should be conducted for newly appointed justices of the Court of Appeal and registrars. Electoral tribunals. In the 6th schedule of the Constitution on electoral tribunals, Section A3 on the National Assembly Election Tribunal provides, I quote, "The chairman and other members shall be appointed by the President of the Court of Appeal in consultation with the Chief Judge of the state, the Grand Qadi of the Sharia Court of Appeal of the state, or the President of the Customary Court of Appeal of the state, as the case may be." My postulation is that the President should be relieved of this political burden. The President has more than enough to cope with in administering 20 divisions of the Court of Appeal all over the country. The Court of Appeal ought not to be involved in electoral matters. Stories of corruption in electoral litigations are too rampant and too damning. The country must rescue justices from political pollution. A special legal system should be created for election litigations without involving the regular courts, including the Supreme Court and the Court of Appeal. Of course, these recommendations will need constitutional amendments. Electoral appeals used to end in the Court of Appeal, but that ended years ago. Appeals were allowed to the Supreme Court. The allegations of corruption are so overwhelming that I vehemently plead that both the Court of Appeal and the Supreme Court should be totally insulated from the scourge of allegations of corruption, which is destroying our legal system. Personnel of the registry. It is canvassed that before new justices and new divisions are appointed, adequate courtrooms, justices' chambers, staff, registry facilities are provided for the effective dispensation of justice. Sufficient staff should be available to assist the justices to perform their very burdensome judicial functions. Further, I regret to say, with pain in my heart, that there are many complaints of corruption against court registries. Thus, adequate supervision is required to ensure that court processes are properly managed by the registry without corrupt practices, which may tarnish the reputation of the justice, because the registry may say, we are doing it for the judge, when the judge knows nothing about it. Adequate infrastructure. The judicial work is so taxing and demanding that government should continue to ensure that adequate infrastructure by way of accommodation, office facilities, staff personnel, courtroom furniture and facilities, and well-stocked libraries are available. Are available for the justices to enable them perform to the optimum. Both the justices and the counsel in appeal must be comfortable in the performance of their roles in the courtroom. The general provisions of the Court of Appeal Act, salaries and allowances of President and Justice of the Court of Appeal are listed in the Act. Certainly, this is important. However, because of the current scandal of corruption, I recommend that ethics and integrity be included in the Act. Technicalities. The Court of Appeal ought to aim at attaining real justice and should not allow technicalities to defeat the cause of justice. The balance between justice and technicality must weigh in favor of justice. In the case of Maersk Line versus Adida Investment Limited, the Supreme Court, per the then Chief Justice of Nigeria, the Honorable Justice Miriam Aloma Mokhtar, held as follows, I quote the former CJN, "The judicial process malfunctions and is discredited when it is bogged down in technicalities and is manipulated to go from technicality to technicalities. This is why at all times the tendency towards technicality should be eschewed and the determination to do substantial justice should remain the preferred option and hallmark of our judicial system." In the Niger Delta Development Council, NDDC, versus Precision Association Limited, the Court of Appeal splendidly followed the lead of the Supreme Court in its determination to achieve substantial justice by holding that, this is you, Court of Appeal, I quote, "The appellant cannot cling tenaciously to technicalities and insist that the respondent's case be dismissed or struck out. The heydays of technicalities are now gone for good. The court is now interested in doing substantial justice. Reliance on technicalities leads to injustice." I respectfully concur. I rest my case on technicalities on those two categorical judicial pronouncements. The principle of stare decidendi. The principle is crucial in achieving certainty of the law. By following precedents, judicial officers ensure the efficiency of the law and the reliability and credibility of the judicial system. Of course, no one is infallible, and consequently, no institution administered by human beings can be perfect. Thus, there will be occasions when the Court of Appeal has to reverse itself for sound reasons, as was done recently. It will amount to judicial ineptitude if a mistake of the past is detected and not remedied for for the reliability of the law. However, such reversals must be extremely rare in order to preserve the rule of law and the principle of judicial precedent. In view of the unprecedented tragedy which befell the administration of justice on the October 21st, 2020 day of infamy, with all due respect, I urge all of us to engage in self-examination, self-introspection, self-questioning, in order to correct some of the mistakes and misdeeds of the past. However, no matter how agonizing the present situation is, we must not give up. We must remain resolute in our resolve to heal the wounds of the past. Let us be encouraged by the words of St. Paul the Apostle in 2 Corinthians 4, verses 8 and 9. I quote, "We are troubled on every side, yet not distressed. We are perplexed, but not in despair. Persecuted, but not forsaken. Cast down, but not destroyed." I pray that God will empower us to overcome our present tribulations. Amen. I now seize this opportunity to acknowledge and applaud all that the Court of Appeal has achieved since its creation, in the midst of all the calamities which now assail the country, particularly the assault on fundamental human rights. The Court of Appeal ruled that the citizens can hold peaceful protests without obtaining police permission. That is in the Constitution, and the Court of Appeal affirmed it. Well, I'm happy to see some representatives of the police here. I now go to obiter dictum. It is a pity that obiter dictum is now missing in judgments. The state of the nation is so lamentable that there should be more obiter dicta in the judgments of the Court of Appeal and the Supreme Court. Law is for social engineering, and when it is necessary to correct a social evil, an obiter dictum should help the society to attend to the social problem. It is a professional duty to speak up. I want to emphasize, our professional duty to speak up for the people against egregious atrocities committed on the people by the authorities and the powerful. In that context, I rely on the profound biblical words in Proverbs 31, verse 9, as follows. I quote, "Speak up and judge fairly. Defend the rights of the poor and the needy." I repeat, speak up and judge fairly. Defend the rights of the poor and the needy. We should not off the mic or stage a fainting fit, as was done recently in the Senate. Thus, with all due respect, I urge you to speak up in your judgments in obiter dicta. Ẹ sọ̀rọ̀ sókè, ẹ sọ̀rọ̀ sókè, ẹ sọ̀rọ̀ sókè. Appearance. You know, when you enter a room, before you open your mouth to say anything, people has already upgraded you or downgraded you. So it is important that the legal profession will stick to a black and white. That's the best in fashion anyway. And It makes us stand out. I know that people say dark colors. I never say dark colors, because if I say dark colors, somebody will come in brown or green. So I say black and white, and I urge the Court of Appeal to please ensure that lawyers do abide by this tradition. And with all due respect to my fair gender, please tell the young female lawyers not to wear danglers earrings, not earrings hanging down. There must be tiny earrings on their ears. I mean, the courtroom is not a disco place. Now, I talk on punctuality. Nigerians, as many of us, disrespect time. And time is of the essence, and time is money. So you cannot quantify what Nigeria is losing by the disrespect that our people extend to time. Of course, the court sits at 9, and if it doesn't, that court owes an apology to the bar for not sitting on time, because the bench they know what to do when lawyers are late. I want to just give you a story about punctuality, which I think you probably will enjoy. I was elevated to the rank of Senior Advocate of Nigeria in 1981. I think it was 2 years after that I received an invitation from the students of the Obafemi Awolowo, now OAU. Well, it was Ile-Ife, now OAU. I went to the Court of Appeal in Ibadan, and as a Senior Advocate of Nigeria, my matter was taken first because I told the presiding justice that I was on my way to Ile-Ife to go and give a lecture to the students. So they took my matter. I was out of the court by, I think, by 9:30. We drove to Ile-Ife, and we got to Ile-Ife about 11:15. The lecture was 11 o'clock. So I went into the hall where the venue, and I saw a few students there. So I sat down. They were coming in 2s and 3s. I just watched in amazement. In any event, around 11:15, this person came in and introduced himself as a lecturer, was wearing a shirt that even a 15-year-old would not want to wear outside. So anyway, he introduced himself as a lecturer, and then by that time maybe the hall was about half full. They were late already. So he then introduced me and said, when he sat down, I told them, I said, when I was a student in England, students waited for their lecturers. Lecturers don't wait for students. I said, you are my is it all right? I don't know what it is. Is it part of the gadget?
Yes.
Okay. Thank you. Information technology. I showed them my election papers. I said, I refuse to give any lecture where I've been so insulted. So I took my bag. I didn't even take my bag. I walked out. My staff came and packed all my stuff. They all rushed out to my car, prostrating and kneeling. We drove off. I mean, I've met some of them. The following week, a delegation came to beg me and to order. Yes, that's all right. But I've met some of them, and they said that was a lesson in punctuality that they will never forget. So that was it. I was so put off. All right? Now, I'm moving towards the end. I want to offer you the 7 social sins by Mahatma Gandhi, the Indian legendary statesman. 1, wealth without work. 2, science without humanity. 3, pleasure without conscience. 4, knowledge without character. 5, politics without principles. 6, commerce without morality. 7, worship without sacrifice. The immortal recommendations of Mahatma Gandhi. And before I go to my peroration, I want to recommend to the President of the Court of Appeal to present a supplementary bill because of coronavirus pandemic and because of the destruction inflicted on the Judiciary on October 21st. Now in peroration, again, I wish this assembly a resoundingly successful event. I know you're going on for the next few days. I respectfully offer to you another profound admonition of St. Paul the Apostle. To the brethren, you know you are brethren, so to the brethren. So this was specifically designed for you appellate judges. It says, finally, brethren, whatsoever things are true, whatsoever things are honest, whatsoever things are just, whatsoever things are pure, whatsoever things are lovely, whatsoever things are of good report, if there's any virtue, and if there's any praise, think on these things. May God help us to heal Nigeria. Deo volente. I pause and I thank you for your attention. But before I go, I want you to know that I brought a copy, well, I brought 4 copies of my autobiography, Reaching for the Stars. I would have brought more, but at the induction for the 72 a few days ago, they were bought. I have 4 copies. If anybody would, after anybody who is interested, can always send it to you through the Court of Appeal. I will get in touch with the Honorable Justice Bada. I also have the authority, I already have the authority of the President. So, ladies and gentlemen, thank you very much. I rest.
May we please give the Chief Mrs. Folake Solanke, CON, another round of applause. It has to be said that she has truly given us one of a lifetime presentation, which was delivered with the customary elan, great dignity, wonderful forthrightness, and indeed a great deal of experience. Mama, we just want to thank you once again. Before I go, I think it is imperative that I also mention that the citation does not truly do you justice, ma'am. I know that you were a commissioner in the western state of Nigeria in 1972, and that you were the chair, I cannot say chairman, the chair of the Western Nigeria Television Broadcasting Corporation, WNTBC, which was the first of its kind in Africa in those days. I know that you are also the Yeye Mofin of Ile-Ife, a title which was conferred to you by the late Oba Okwade Shijuade Olubushe II, the 50th Oni of Ife. And so Mama is indeed a woman of many colors, many achievements, and indeed many things that she has done for Nigeria. And as you can see, Mama is indeed current with 2020 slang because she encourages us to sorosoke. I hope that it would not be out of turn to say that our Mama has fed us from the fruits of knowledge and from the wellspring of a wisdom garnered over many decades of excellence. One can truly say that Mama has not only reached for the star, but you are indeed a star. God bless you, ma. And we say, may God Almighty continue to bless you and keep you in soundness of mind and body for many years to come. I say a big amen, and I pray that we all say amen to that. At this point, we'll be moving over to the question and answer session. Because of time, we may have to make it a little bit brief, but our staff are going around, and if you have any questions, please indicate with the raising up of hands. Oh, I beg your pardon. And before that, yes, we shall have brief comments from the Chairman of Session, Honorable Justice R.C. Agbo, JCA, PJ Owerri Division. Can we please give him a round of applause? Thank you, my Lord.
First, by saying that we have to deliberate on how to restore golden age of justice. And going to the wide range, very wide range discourse of the problems of the judiciary institutions. I was too timorous right now. It was good. So, we are going the advantage of taking full knowledge, pure knowledge from it. And we are not going to go to full knowledge. We are going to go full age as done. Then we don't need to go to bed today. Stay with us. We are ready. And then we'll release her. A few questions from us, the issues raised and discussed. Yes, gentlemen. Please, show of hands. I hope you are not all too intimidated for not asking questions. Yes. Well, thank you very, very much. I'm not the only person intimidated here. My President, no questions. Yes. Thank you, my dear. Thank you. I'm most grateful. Thank you. Yes. Nobody has it. No. So, thank you, gentlemen. I think I see you're getting too hungry. Aha, finally. PJ Gombe.
My Lord, the Honorable President of the Court of Appeal, my Lord, the Chairman of Session, our mother, the distinguished, illustrious, and Latin and mathematics in the UK. It was amazing. You excelled there, and you now excelled again in the profession of your choice as a legal practitioner. In fact, we look up to you, and each time I see you, I mean, you are an embodiment of mentorship in even the way you walk and the way you carry yourself. We thank you very much, Ma, for making time to come and speak to us. So many things that you spoke about today were very close to our hearts and were very interesting. But what I want you to perhaps say a little more about is the issue of the courts, the regular courts, handling election matters, both at the tribunals and at the appellate level. We know what we have suffered at the hands of politicians. When we take our regular matters, there's hardly any hue and cry. We do our best. But when it comes to election matters, we are bombarded with a lot of accusations. And it is so difficult for every election year. There is so much stress that justices and judges go through. Now, I remember when I was at the High Court, there was once a proposal for the setting up of a constitutional court. I think that time it was to be made of about 32 judges. And it went a long way. They had even shortlisted judicial officers who were to serve on that. And the, I think, intention at that time is, like you said, to insulate the generality of the court from being affected by politics and politicians. But I don't think it was popular, either with the government of the day or the leadership of the judiciary at that time. And even though it obtains in so many countries of the world, it never saw the light of day in Nigeria. So I don't know how, what is your advocacy on it? What are the pros and cons? What was it they were afraid of in taking it away from regular courts and setting up a constitutional court that would every 4 years deal with these matters and allow for regular courts to continue? Thank you, Lord. Thank you, my lady. Thank you.
Yes, sir. Another contribution. Yes.
My Lord, the Honorable President of the Court of Appeal, all protocols duly observed. We thank Mama for the thought-provoking lecture that she has given to us. But there is one important matter also, which I believe that no one appears to be talking about it or fighting for the justices, not only of the Court of Appeal, but judges of all jurisdictions throughout the country. The last time the salary of judges was reviewed was in 2007, and like a stagnant water or stream, the justices of this court have remained on one salary for over 13 years. For example, when I came on board, I was receiving and still receiving the same salaries with those who are my seniors in this hall. Many of them have been here for 13 years, 14 years, 15 years, yet we are on the same salary. And nobody appears to be talking in favor of judiciary or justices about this. All they want is that they want the judiciary to make sacrifice, and to bring us down. Thank you.
Yes, gentlemen.
My Lord, the Honorable President of Court of Appeal, the wonderful, unique presenter. My Lord, Justice Ada is the one. Justice Ada, Stephen Ada.
Please raise the voice, Justice Ada.
It's not the voice, it's the microphone. Thank you.
Please, when you stand, identify yourself so the speaker doesn't know all of us.
Okay. I am Justice Stephen Jonah, Buja Division of the Court of Appeal. I want to congratulate presenter this evening for this wonderful, unique lecture she has delivered to us. And I was really particularly touched about how much you felt on October 21, 2020. That truly was not the day Judiciary died. The day Judiciary died was the day the military used DSS to go and arrest and treat like common criminals justices of the Supreme Court of Nigeria. And instead of having a united front against hooliganism from the executive, no one in the legal profession maintained a balanced opinion. Rather, they succeeded in dividing the ranks of all of us, and people were calling us names. And it has come to the level now that some of us are so demoralized. Sincerely, I felt this is not the judiciary that I dreamt of, that I entered. At a point I said, is it not even better for us to get out of this job? The last blow was the current one that is trending, where the ICPC chairperson, who is a learned senior advocate,
designate,
now have taken on the judiciary and now say that we are the worst corrupt institution in the whole country. I mean, this one has not looked at the National Assembly and the politicians. He's not looked at the executive. He went in-house and removed the roof over our head. And this continues unabated. And because they have started from high quarters in giving us this bad name, this is what the aura of all of us justices and the law profession has turned into. And this statement is quoted all over the world because we're in the age of technology superhighway. Everywhere in the world, they know Nigerian judiciary is damned corrupt. What can we do to stop this assault? Do we have to close down and let the country run on its own without the courts or the judiciary for once? What is the solution all the way forward? Thank you, my Lord.
Any more contribution? Any more contribution?
Yeah, thank you. I appreciate it.
Please, look at the right microphone. Bring the microphone.
Thank you. Thank you very much for the interest that you have shown in my presentation. With reference to the lady here, I watched you were taking notes, so you were very interested in what I was saying. I think that the issue of constitutional court, we have to return to it. And I'm sorry to say that the Court of Appeal has to be the leader in its own battle. So it's a challenge for the President of the Court of Appeal to try and design a program when the justices themselves can articulate their problems, and then the President will know how to present them to the authorities. So you have to think of what to do within yourselves. I agree with you that they should take away all the electoral matters from the regular courts And we should remind everybody that we wanted to have a constitutional court before we have to resume our agitation for that. And then about salaries, it's really grievous to know that salaries have stagnated since 2007, and it's a matter again that the judiciary must not be silent upon. The judiciary must be ready to articulate its problems and to point out that this cannot be right. The better judges are paid, I believe that with due respect, the less the temptation for wrongdoing. So indeed, the emoluments of justices must be improved. What I intend to do is to get in touch with the president of the Nigeria Bar Association and to ask him how we can bring all these matters back to the front burner so that we can deal with them. So I will tell Mr. Apata, my learned friend, the president of the Court of the NBA, I also was very pleased to hear about the assault, the nocturnal assault on the homes of judges a few years ago. I went to church on that Sunday. I think it happened the night before. And I read in the newspapers about it. I wept. I couldn't stop the tears. I couldn't believe they would go and attack judicial premises like that. I wept. So I agree with you. That also was a day of infamy when that happened. And a day of infamy was another one when, I think his name was Duru. I believe maybe he has passed away. He was in the Supreme Court ex facie and was telling them that they are corrupt in the bowel of the Supreme Court. That was the first day of infamy. The other day is what you are just referred to, the assault of the premises. So we have to, you have to, I will go into conversation with the President of Court of Appeal so that you know how to bring these problems. It's no good complaining without bringing it to the attention of those who should do something about it. We have these three arms of government, but you know, I think that the most important is the judiciary, because we are the people who resolve problems when the other two are in trouble. So let us just make sure that we do all we can to bring our problems to the fore. I think I've covered the points that I noted in my notebook.
Thank you, gentlemen. It's time to release our honored guests to go and have a good night's rest. Thank you very, very much for honoring our invitation.
Yes.
We'll call you again. Please come.
Thank you.
Thank you. I think you are free to go.
All right.
We'll see you.
Thank you very much.
With the kind permission of the Honorable President of the Court of Appeal, we would like to invite the Honorable Justice Hussaini Mukhtar, Justice of the Court of Appeal, to please come forward and deliver the closing prayers for the evening. Thank you very much, sir. My Lord, the Honorable President, permit me to stand on the existing protocol. The prayers, I will say, will be in Arabic, but in a nutshell, it prays to the God the Almighty to continue to guide us righteously in whatever we are doing officially and privately, and to grant us every good in this life and in the hereafter, and to prevent us or save us from the torment of the hellfire, and also to take us back to our respective destinations safely, to also continue to guide our leader, the Honorable the President, righteously, and continue to give her more wisdom, and to continue to guide all of us here who are leaders in one way or another, to continue to steer the affairs of our respective divisions and the entire court in the most righteous direction. May God the Almighty continue to uplift and raise the Court of Appeal of Nigeria to greater heights. Sallu ani Nabi sallallahu alayhi wa sallam. Allahumma salli ala Sayyidina Muhammadin wa ala ali Sayyidina Muhammadin kama sallaita ala Sayyidina Ibrahim wa ala ali Sayyidina Ibrahim wa barik ala Sayyidina Muhammadin wa ala ali Sayyidina Muhammadin kama barakta ala Sayyidina Ibrahim wa ala ali Sayyidina Ibrahim fil alamin innaka Hamidum Majid. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alamin. الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار ربنا هب لنا من أزواجنا وذريتنا قرة أعين واجعلنا للمتقين إماما اللهم أنت رب لا إله إلا أنت عليك توكلت وأنت رب العرش العظيم ما شاء الله كان وما لم يشأ لم يكن لا حول ولا قوة إلا بالله العلي العظيم أعلم أن الله على كل شيء قدير وأن الله قد أحاط بكل شيء علما اللهم إني أعوذ بك من شر نفسي ومن شر كل دابة أنت آكذ بناصيتها إن ربي على صراط مستقيم سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين. My Lord, we are most grateful indeed for those wonderful prayers. We shall now please may we please be seated here, because I am reliably informed that the dinner will be served in this particular wonderful location, so we may want to sit down, have a brief conversation and chat with our colleagues while dinner will be brought in and served. Thank you all very much, and I pray that you have a wonderful evening, my lords. Thank you very much. Oh, sorry. May we please rise for the National Anthem as we close. Thank you very much. Arise, O compatriots, Nigeria's call obey, to serve our fatherland with love and strength and faith. The labor of our heroes past shall never be in vain. To serve with hearts and minds, one nation bound in freedom, and unity. Thank you very much, my lords. Please be seated.